Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. Okay, before we get started, I have to tell you the coolest thing I just figured out. So as you know, I'm old and I'm not the most tech-savvy person. So I just used ChatGPT to plan my holiday shopping, my holiday menus, even when I put in the turkey, when I make the potatoes, when the gravy comes out. It's unbelievable. So if any of you have been not using this amazing AI, I don't know. It's so crazy. I cannot believe it. I literally have a chart of how to do everything for the holidays, and we're only a week away, so I am so grateful. Okay, so what we're going to talk about today is the risks of modified duty programs, okay? And those of you who know me or have heard me speak before know that I sort of get a bee in my bonnet about workers' compensation programs. And let me tell you what I mean by that. Workers' compensation carriers are terrific. They are overworked. They are underpaid. They are under-resourced. And they try to help us as much as they possibly can. Okay, that's just a fact. The problem is they often want to give employment law advice when what they really need to do is stay in the workers' comp arena. And this is a perfect example of when that can happen. So as you know, your workers' comp carrier will always suggest, recommend, cajole, beg, direct you to bring somebody back to work if there's anything they can do. Anything the employee can do, because if they're at least doing something and they're making generally 80% of their pre-injury or pre-illness compensation, then your mod rate stays down. The workers' comp carrier saves money, the person's back to work, which a lot of research indicates gets the person well more quickly. All right. All of that is fabulous. The problem is, to get people back to work, you sometimes have to take away the essential functions of their job. Remember, you only provide an accommodation to someone for a medical condition or disability if they can perform the essential functions of the job with or without the accommodation. In other words, if the accommodation will not allow them to do their job, then they are not entitled to the accommodation. Here's what happens with workers' comp. I'm a retailer. This person who's been injured is supposed to stock my shelves. They've hurt their shoulder and they cannot lift and they cannot squat and they cannot turn. They can't do anything. So I sit them at my fitting room and I just have them sitting there telling people where to go in the fitting room. They don't have to lift anything. They don't have to do anything. Okay. It works. And I can pay them their regular hourly rate for that. I'm happy. They're back to work. The carrier's happy. They're back to work. The employee is probably happy that they're back to work, at least on some level. So everything's good. Now you get an employee who hurts themselves skiing. And they come in and they say, oh my gosh, I can't stock the shelves. I can't bend. I can't squat. I can't lift. I've got a shoulder injury. I know you let Tom sit in the fitting room when he was injured a few months ago. I want you to let me do that too, because I need my health insurance. I want to still get all my accruals of vacation and sick leave. I want to be paid for the holidays. So I want you to bring me back, but I can't go back to my regular job. All I can do is sit at the fitting room. And you say, Jen said we don't have to accommodate if they can't perform the essential functions with or without accommodation. Okay, no accommodation, dude. Sorry, you can't perform the essential functions, which would be a great answer, except that you just accommodated the other guy who also can't perform the essential functions. And you let him come back to work and sit in the fitting room. So you have to treat your employees who are injured at work the same way you treat people who are injured at home or outside of work. And actually, it's better to think of it the opposite. You have to treat the people who are injured outside of work at least as well as you treat the people who are injured at work or who become ill because of work. In other words, they have a workers' compensation claim. Otherwise, you are discriminating. Do you see that? Okay, because what happens is you're saying, oh, if you're injured at work, I'm going to go ahead and give you this job that doesn't require you to perform your essential functions. But if you weren't injured at work, I'm not going to let you do that. And now I'm treating you differently because of the nature of your injury, which is a per se discrimination claim. All right. And the carriers will tell you to do this all day long, just like they will tell you to do automatic post-accident drug testing. Somebody gets a paper cut, they file a workers' comp claim, they want you to go drug test them. In California and most other states, you can't do that because you have to have reasonable suspicion to test. Now, you might have a safety sensitive position. Somebody is in law enforcement. Okay, great. They're in law enforcement. We don't have to have a reasonable suspicion. We can actually do random testing. Automatic post-accident testing is fine. But otherwise, you have to be able to show that you have treated people fairly and equally, and you cannot do automatic post-accident drug testing. There are other myths about workers' comp, right? Oh, if somebody's on workers' comp leave, which as you all know does not exist, there's nothing in the law related to workers' comp that gives anyone the right to take time off, okay? The right to take time off comes from the Family and Medical Leave Act, the California Family Rights Act, the Americans with Disabilities Act, the California Fair Employment and Housing Act, the policies and procedures you have implemented, okay? That's how you get leave. So people will tell me, oh, when they're on workers' comp leave, you can't designate FMLA leave. You can't count it as FMLA or CFRA leave. Of course you can, and you must. You are required to do that. Those employees are entitled to the protection of those laws. So when we're talking about workers' comp, whether we are talking about modified duty, we are talking about leaves of absence, we're talking about having to let people keep their job forever. People will tell me, well, Jen, she's been on workers' comp for 7 years. I don't think I can get rid of her. Are you kidding me right now? Of course you can. Now, it won't necessarily affect the workers' comp claim, which is great, but they're not entitled to unlimited leave or pay while they're out unless it's through the workers' comp system, or continued health insurance benefits unless they're on FMLA or CFRA or some other program that allows them to have those continued benefits. So when you are interviewing an HR person for a new job, okay, you're adding someone to your team. If you ask them the question, what are the risks of having a workers' comp modified duty program, and they can't identify that for you, they're not somebody who is an experienced HR professional. Because I work with a lot of you who listen to this podcast, and I know you're driving down the road or you're in the gym and you're nodding your head. Yeah, Jen, I know, we got it. Okay, but not everybody understands this. And it is really important for you to know that you cannot draw a distinction between somebody who is injured or ill at work and somebody who is injured or ill outside of work. That is a critical liability issue. And in the old days, okay, lawyers, plaintiffs' lawyers were not savvy to this issue. So they didn't go make claims in this area. They never raised a concern about, well, wait a minute, you do it for people on workers' comp. Now it is a standard question in depositions. Okay, now it is a standard issue that comes up in court decisions. So you have to be really, really careful about this idea of making sure that you understand what your obligations are under each law, because you're not always going to understand that. And you've got to make sure you get it. Okay. So couple of recommendations. It's almost the beginning of the new year. You know you need to review your employee handbook. As you know, if you listened to the podcast last week, I guess it was 2 weeks ago, actually, you should join our webinar that's coming up, which will be fantastic for helping you to understand what you need to do for your handbooks. Second of all, I want you to read them with a very eagle eye. And I want you to think about anything in your policies that you may be doing differently because of workers' comp. And I want you to carefully evaluate that with your regular employment law counsel, not your workers' comp carrier counsel, your regular employment law counsel, okay? We all have to stay in our lane. So somebody asked me the other day, Jen, can you help us with a labor election? Okay, so somebody wants a union. There's a group of people in this workplace who want a union. They want me to help them. I love labor law, but I haven't practiced it for 10 years. And I said, nope, I'm not your person. Can't do it. Wish I were, can't do it. We have to stay in our lane. So it's really important when you're thinking about what information you are getting from your workers' compensation carrier. Remember that we all have an interest. Your adjuster has an interest in getting their cases settled for the lowest amount, making sure they're on top of what the rights and the benefits are, understanding what's going on, right? Step by step. They have their own interest. Their interest is not employment law. And that's not because there's anything wrong with them. Like I said, they're fabulous, but they're in their own lane. So you have to be sure that you are staying in your own lane with them. Right? So you're going to have a modified duty program. You want to bring people back to count hangers or let people in the fitting room or do computer work when that's not what they usually do. You can do that. I'm not telling you can't do that, but you do it for everyone. You do it for the folks who are injured or ill at work, and you do it for the ones who aren't. Okay? Now, a couple of important reminders. First of all, remember that the Greater San Fernando Valley Chamber of Commerce has additional funding for their paid leave grant. We just got one because one of our fabulous lawyers was off work, Christabel, to have a baby. And we, of course, gave her time off and she applied for paid family leave and she got those benefits. And we got a refund. We got some money from this grant, the paid family leave grant. So to find out if you're eligible, you can apply for the grant at www.california, P as in Paul, F as in Frank, L as in love, PFL.com. Okay. I also want to remind you about our legal update webinars. They are coming up. They are filling up very quickly. I'm not sure what's going on this year, but we've already got some that are near capacity. So please sign up for those. They are critical. It is a huge investment in compliance, avoiding Private Attorney General's Act claims, everything you need to do. So just go to our website, go to the training portion of our website, and you'll see it right there. Very important that you get in on those, okay? Finally, everyone, thank you for supporting us for yet another year. Here we are almost at the end of 2024. You have no idea the joy and the satisfaction I get from doing these podcasts and getting your feedback and working with all of you. Some of you I get to talk to almost every day, which I love. Some of you I don't get to talk to, but I hope you know that I'm so proud of what our HR friends do. I don't care if you're in-house, out-house, if you're an HR consultant, you're a VP of law, of legal, whatever you do, if you're dealing with HR issues, I feel your pain, I feel your joy, and I'm so glad that you're able to join us here. I cannot believe we're coming to the end of another year, but it is a beautiful rainy day here in Sacramento, and it's just been such a pleasure to record this podcast today. So thanks, everyone. Go out and do something nice for someone, and I'll see you next week. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.